Greetings. Here's what I want to do. This video is actually going to be the first part of a series about drafting applications to account for 101 issues. And in this first part of the series, I'm basically going to present a very cynical take on Section 101 and how to kind of deal with it from a cynical, almost nihilistic perspective. The second part is going to be me describing why the cynical, nihilistic approach isn't really, I think, the best approach to take. I think it overstates things. I think that it can be counterproductive. So yeah, and then in the third part, if all goes to plan, I will synthesize what I've discussed in the first and second parts to explain what I see as being a effective approach to drafting and accounting for Section 101 issues. Anyway, let's start. Let's get started with looking at drafting for Section 101 from a kind of cynical approach. And where this came from, so I was reading Reddit, and there was a thread on a case called Bongiorno, I think is how it's pronounced. Honestly, I'm not 100% sure, but essentially this was a case, it was from a patent application. They had appealed at the Patent Trial and Appeal Board. They lost. They said the claims are directed to planning and executing a vacation or travel itinerary, and unsurprisingly, the Federal Circuit affirmed the PTAB. So, okay, the Federal Circuit finds claims ineligible. That happens a lot. Not always really big news, sort of dog bites man kind of thing. This case, though, I think it's the kind of case that one might be cynical about. The claims that were being addressed were about 4 pages long. The analysis that the Federal Circuit used was about 1.5 pages. And, you know, they said, you know, I could have told you what was going to happen in this case once I saw how they characterized it. When they said, look, this is planning and executing a vacation or travel itinerary, I don't really even need the rest of that 1.5 pages of analysis because I know where this is going. This is going to be, you are an abstract idea and we're not going to give you a patent, because when they characterize a claim that way, that's just what, I mean, that's what seems to happen. And in this case, that is what happened. And they said, look, you know, there are, you know, a whole bunch of elements, right? The claims are, you know, pages and pages long, but they amount simply to applying the abstract ideas using generic computer components performing routine computer functions. And again, that's the kind of statement that might make one a little cynical, because we know from what happened at the PTAB that that is just not true. And we know that that's not true because there were also 103 rejections. And those rejections, not all of them, right? So there were some claims that had 103s that were affirmed, but there were a number of claims that had 103s reversed. And, you know, if all we were dealing with was generic computer functions doing things that were routine, they would also be obvious, because by definition, if something is done routinely using known components, then it's going to be part of the prior art. And in this case, as I said, you know, they reversed many of the rejections. So we know that what the arguments given, the justification, even though it was only 1.5 pages long, didn't really seem to fit the facts. And in this thread on Reddit where I saw the case, one of the commenters had a question, and the question was, all right, how do you stay away from result-based claiming, right? Because that's what they said, simply applying the abstract ideas using generic computer components performing routine functions. And they said, no, there are no sort of innovative programming in order to achieve this. You're just reciting result. And the commenter said, how do you avoid result-based claiming, particularly with software or business methods? And I looked at this, and the cynic in me says, you are asking the wrong question. Because this implies that there was something you could have done, right? And we already know that they did, in fact, have tremendous detail in the claims, right? Pages and pages of it. And we also know that at least some detail was innovative, or at least innovative enough to not be obvious. So what are they supposed to do? Well, you know, I don't know that they're... you look at this and you're like, is there anything they even could have done? Maybe not. The question sort of implies that there are rules that if you follow, they'll allow you to reach a desired outcome. But the problem is, for subject matter eligibility, the rules don't really have a lot of meaning. They don't really act to constrain. If a judge says, hey, I don't like travel itinerary patents, what rule is going to stop them? And in fact, we know the Federal Circuit, they can't really even decide on whether the rules are a change, right? Even such a basic question of, hey, did Alice actually even change the rules? Is it the same? We've got cases. So, for example, there's a case, Inventor Holdings versus Bed Bath & Beyond, which was an attorney's fees case, and the patent holder said, hey, we shouldn't have to pay attorney's fees because we asserted these claims in previous cases, and we turned back 101 challenges. And so the fact that, they're now being invalidated under Alice, that shouldn't be enough to, we shouldn't be treated as having an exceptional case because the claims were apparently found to be clearly invalid under Alice, because we had won in these previous determinations. And the Federal Circuit said, nope, Alice was in fact a significant change in the law, and it was the patent holder's responsibility to reassess its case in view of that new law. So, right, clearly, this is a change in the law. On the other hand, in voter verified versus election systems and software, this was an issue preclusion case. The Federal Circuit took basically the exact opposite. They said, look, we conclude Alice, which was decided after, in that case, the first litigation, did not alter the governing law of Section 101. So in one case, they say it does, and there was an attorney's fees decision based on it, and the other, they say it doesn't. And so in that case, they still said issue preclusion didn't apply, but it wasn't because of an intervening change in law, because they said there was no change in law because Alice didn't change the law. So if you can't even get that, if you can't even get agreement on, hey, did this change the law, how can you rely on these rules? It seems like, I guess the cynic in me would say that subject matter eligibility is like global thermonuclear war. The only winning move is not to play. All right, well, what does that actually mean? Well, what that means is, look, you say, this is a sucker's game. I can try and be like this Reddit commenter and say, oh, how do I avoid results-oriented claiming? Or I can say, there's nothing I could have done to avoid being treated as results-oriented claiming or insufficient extra solution activity or whatever reason they wanted to use in order to kill the claim. What I should have done is opted out. And I should have said, I don't believe in this abstractness. What I'm going to do is I'm going to be more abstract. And how could that help? Well, the reason that can potentially help is, at base, the problem with the claims was because they were directed to something that seemed familiar to the judges. They seemed familiar to the Patent Office, they seemed familiar to the PTAB, and that is travel itineraries. Like, everybody's made a vacation or travel itinerary. It seems familiar, and they say, hey, familiar things, human activity, you shouldn't be able to get a patent on that. If it's something familiar to me, that just doesn't feel you should be able to get a patent on it. Instead, it should be more abstract. Look at it from a higher level, sort of step back and say, hey, wait a minute. A vacation itinerary, you can kind of treat this as being almost a special case of like route finding, right? Determining ways to go from point A to point B, what the various constraints are, how you do this in an efficient manner. And, route finding is something that, that shows up everywhere, right? That goes from, look up like the traveling salesman problem, and you'll see that can be used in everything from semiconductor chips to engine overhauls to X-ray crystallography. I mean, it's all over the place. And if you say, look, we're going to be more abstract, we're not going to talk about the actual practical application that justified this patent because that's something that, people use every day and therefore will seem familiar and they might not like it because it's against their sort of policy on patents. If instead you say, hey, let's step back, we're going to be more abstract and do something that encompasses a whole lot of stuff, maybe you're going to have better luck because they won't even consider that it's something that shouldn't be patentable because, hey, if it can be applied as a tool in things from X-ray crystallography all the way to, semiconductor chip design, then, you shouldn't have to worry about this abstractness stuff. And in fact, if you look at the cases, that is, it appears that that's essentially what works, right? So there was a case in read TLI communications, and in read TLI communications, what you have is claims that are directed to classifying and organizing stored digital images in an organized manner. Classifying and storing digital images in an organized manner. So you're basically organizing pictures. All right, so they say this is abstract. Not surprising, right? Because everybody's organized pictures seems like the kind of thing they'd be familiar with and they would not be comfortable saying is patentable. All right, well, you also have Enfish versus Microsoft. Enfish versus Microsoft is directed to a innovative logical data model for a database, and they explained a data model is a model of data that tells the computer how various elements relate to one another. So this is a model that organizes data in a database. Now, you could use that for organizing images. And in fact, in read TLI, they didn't use the Enfish data model, but they had their own way of classifying and storing digital images in an organized manner. If they had been more abstract, if they hadn't said, look, we're focusing on this particular application, but instead talked about, here is how we're going to treat the computer and improve it as a tool so it is better at organizing information. The fact that they didn't happen to mention the information was pictures might have brought them closer to Enfish. And in fact, one of the things Enfish talks about is improving the use of a computer as a tool rather than using it as a tool is the reason why that was patent eligible, and in fact wasn't even directed to an eligible subject matter, wasn't even directed to an abstract idea, even though at base both Enfish and in read TLI were about organizing data. It just happened one of them was about organizing a specific type of data that was data that would have been familiar to the fact finder. So in any case, that's what the cynic might say. And looking at this again, it is easy to have that kind of a cynical reaction to it. But ultimately, I think that's wrong. And what I'm going to do, I'm going to leave that here for now. And in part 2 of this series, I'm going to talk about why that's wrong and why actually taking that cynical approach, which on its surface, right, cynicism seems very appealing because you can say, look, I don't have to deal with this frustration. I can just say, I'm so world weary, I'm above it all, and I sort of see the truth, and therefore I'm going to be a smart person and be very cynical about this. But why that can actually be very counterproductive here. So in any case, that's where we start off in terms of how to deal with 101 is there's a cynical approach. I think it goes a little bit too far. And in part 2 of this series, I'm going to talk about why. In any case, stay tuned. And until then, good patenting and good luck. Bye-bye.